All right. Good afternoon, everyone, and thank you for taking time out of your busy schedules to join us today to learn about changes to employment laws for 2023. WorkWise Law is one of LACMA's preferred partners, and they can be found on the LACMA Solutions portal. So I encourage you all to check out the portal when you get a chance and check out all the exclusive discounts, benefits, and service that's available to all members. You'll find the link in the chat. I'll go ahead and briefly introduce both speakers, and then we can move into the presentation. And just some housekeeping rules. Before we start, we're going to ask that everyone mute themselves and add in any of your questions to the chat, and we'll answer them at the end of the presentation. Our two speakers today are Alexis James and Renee Noy. Alexis James is managing partner, and she's practiced employment law in California for more than 17 years, having worked on both sides of employment law, of the employment law equation. She earned her bachelor's degree in public policy at Duke University and completed law school with honors at Northwestern School of Law, Lewis and Clark College. In her litigation practice, Alexis has successfully assisted in taking discrimination, harassment, and wrongful termination cases through arbitration and trial, and has been known by her peers to be a voice of reason in contentious situations. In her practice, Alexis conducts comprehensive internal audits, drafts policies and procedures, coaches employers through disciplinary and termination issues, performs employee trainings and investigations, and represents employers in state and federal courts and before administrative agencies. Her husband is a medical malpractice defense attorney at CAP MPT, and they share a passion for protecting the medical community. And our other speaker is Renee Noy, who's also a partner at WorkWise Law. She's earned her BA summa cum laude from the University of Colorado at Boulder in 1997. And received her JD from the University of California at Hastings College of Law in San Francisco. Renee received her mediation certificate from the Strauss Institute for Dispute Resolution at Pepperdine University. Renee has been practicing for over 18 years and has represented hundreds of small and medium-sized business owners in employment discrimination lawsuits, including cases involving disability, race, gender, and age discrimination, sexual harassment, wrongful termination, and a variety of wage and error disputes. With a deep understanding of the specific pitfalls that employers often make that lead them into the courthouse, Renee now helps employers minimize their legal risk with expert knowledge, instructive training, and preventive action. She uses both her legal expertise and passion to decipher and explain the complex myriad of employment laws and regulations. She is goal-oriented and always advises the most direct actions for immediate resolutions, keeping in mind budget and legal protection. Renee prides herself in ensuring that the legal requirements and process are followed so that outcomes are fair and productive for both the employee and employers. Her ultimate goal is to help employers prevent making costly mistakes. With that, I will go ahead and hand it over to our speakers, and we can have them begin the presentation. Thank you.
Thanks so much, Lisa, and thanks for the introductions. We're happy to be speaking to LACMA again. We have met many of you over the years, and it's truly a pleasure of ours to work with the medical community. So we are here to talk today about legislative updates in employment law. And the legislature, as ever, was busy this year in churning out new regulations, some of which were very industry specific, up to and including goat and sheep herders. So we're not going to bore you with the laws in that area. I don't know if you have a side hustle with goat yoga, but if you do, call us. We are going to focus on the laws regarding leave protection, wages, COVID, OSHA regulations, the things that you really need to know for your medical practice. So as we advise every year, when it comes to rights that your employees are entitled to, It's not only important for you as the business owner to know these laws, but also to train your managers and your supervisors, because they are often the voice of your company, your practice, when they're responding to questions from your employees. So it's really important that they know what these employees are entitled to in terms of paid sick leave or leave protection, so that they don't unknowingly get your practice into trouble. So we're going to run through the most important laws, and then we'll take some Q&A afterwards. So the first one I'm going to talk about is AB 152. We only have a few more weeks to deal with this, but this is the California supplemental paid sick leave for COVID reasons, which the legislature extended until December 31st of this year. So this does not give employees a new bucket of time if they've already used their 80 hours of COVID paid leave this year. But if they haven't, and they unfortunately come down with COVID or they're getting a vaccine in the next few weeks, you want to be mindful of this leave. This is only for companies with 26 or more employees. And the way to count to 26 is not only one facility, but if you have multiple facilities, even if you operate in different states, the employees in those states are going to count towards your number of 26. So it's important to be mindful of that. So the way that this is calculated is your employees can get up to 40 hours, their first bank of time, if they themselves are sick with COVID, if they are in a quarantine or an isolation period, if they're starting to show symptoms and they're waiting for a medical diagnosis, that time spent waiting could be paid time. You can also get that first bank of 40 hours if you're caring for a family member who has COVID, or if the child's school is closed because of a COVID-related reason. You can also get up to 40 hours in that first bank of time if you are getting vaccines or are experiencing some side effects from those vaccines. The second bank of 40 hours only applies if you are still sick or your family member is still sick after 5 days of having COVID. And so one change to this law, which was important for employers, is that they can now require employees to get tested for COVID after day 5 if they want to receive that second bank of paid sick leave. We were receiving a lot of questions from employers saying, you know, my employee just doesn't want to take a test. They just want to stay home the full 10 days without testing and have that be paid time. So now the employer has a little bit more control in saying that, yes, we can require a test. And the rules for coming back, I'm sure most of you know this now, I hope you have been through all this before, is that if the employee has tested negative after day 5, their symptoms are resolving and they are fever-free for more than 24 hours, they can come back to work. If they don't test or those 2 other factors are still at play, they can come back after day 10. One important note of this extension for paid sick leave is that the legislature created a grant to help small businesses if they're paying out a lot of money for paid sick leave for their employees. You can apply for a $50,000 grant. This is going to be in place until January 1st of 2024. We put the criteria for how you can qualify for this grant here. You have to be a C or an S corporation, a limited liability company or partnership or limited partnership, or a nonprofit. You have to have been operating since before June 1st of 2021, be currently operating, have 26 to 49 employees, and have been paying out this paid sick leave. So even if you paid it out at the beginning of the year, you can still recoup those costs, which is a nice thing that was not offered previously. And again, the employer can require a test on day 5. They can also require a test more than 24 hours after day 5. So if you want to see if your employee can come back on day 7, you can require another test. And it can be a home test, that's fine. Let's talk about drugs for a minute. And I don't know why, but this week has just been bananas for me because I've had 2 employers with preschool teacher smoking pot in the bathroom, and a driver that was hiding his vape pen in the car. So this is becoming a prevalent issue. I don't know, maybe everyone's just really stressed out. But the legislature is trying to balance the needs of employees who engage in cannabis use off duty on their free time, it's legal, with the needs of employers to have safe workplaces and to make sure that employees are not impaired while they're working. So this new law has been signed into law, but will not go into effect until January of 2024. So we have quite a bit of time to review our drug and alcohol policies and to get some things into place. But just to be mindful of what's happening, this law prohibits employers from discriminating against employees based on their use of cannabis off the job and away from the workplace. And you cannot use drug screening that's going to find the employee had non-psychoactive cannabis metabolites. I have to try and say that 3 times fast. Non-psychoactive cannabis metabolites in their hair, blood, urine, or bodily fluids. So when you are sending your applicants for drug screening prior to employment, or if you have a reasonable suspicion that they are under the influence, you are going to have to take a look at which drug screening you can perform that's not going to run afoul of these laws. The only exceptions to this are construction trades and those that have security clearance from the federal government. I don't think that's going to apply to anybody here. I was surprised that medical practices were not exempted from this, but they weren't. So this is something, again, to be putting your policies and procedures in place in the next year. Okay, next is AB 1126, the Cal Savers Plan. So last year we advised that if you had 5 or more employees, you had to register with Cal Savers or provide a private retirement plan for your employees. The legislature is going further now, and if you have 1 employee, by December 31st, 2025, you will have to also register for either Cal Savers or a private retirement plan. For this Cal Savers, if you haven't heard about this in the last year, it's really important that you go onto the Cal Savers website and register your business as being exempt if you already provide a retirement plan for your employees. There are penalties if the government finds that you have not registered yourself. So do it as quickly as you can, and get off their list. So again, just go on the Cal Savers website and either register that you're exempt or sign up for their free plan. Employers do not have to have any form of match for retirement. They just have to provide a vehicle for their employees to donate to their retirement funds if they wish. SB 1477 has to do with wage garnishment limits. And again, we have a little bit of time to get used to this. It's going to be effective in September of this year. It reduces the amount of wages that you garnish in an employee's paycheck. So if you've received a court order for child support, for alimony, reasons why you have to garnish your employees' wages, there are now limits as to how much you can do per paycheck. It's one of 2 formulas, and it's limited to the lesser of 2 amounts. It's either 20% of disposable earnings for a week or 40% of the amount of disposable earnings that exceed 48 times the state minimum wage. That's a mouthful. So January 1st of this year, the state's minimum wage goes up to $15.50 an hour. Your office might have a higher limit if you're in a city with a higher minimum wage ordinance, but in general for the state, it's $15.50. So 48 times that would be $744. So you're looking at 40% of $744. And next we're going to turn to Renee.
Okay. Hello, everybody. All right. So the next rule has to do with CFRA, which is the California Family Rights Act. So this is just as a way of review. That nothing has changed until the next part I'm going to tell you. But for all companies of 5 or more employees, CFRA does apply. What it does is it provides job protection to employees who have worked for their employer for 12 months and 1,250 hours in any 12-month period for family care and medical leave. So what that means is for the birth of a child, placement of a child in connection with adoption, foster care, leave to care for a child, a parent, grandparent, grandchild, sibling, spouse, domestic partner. And now the new caveat that just got added is now you can call somebody a designated person. So if anyone that you designate, the employee has the right to just choose a person. If they have some sort of medical issue and they want to care for that person, as long as they've designated them, then now you have to be able to give them that CFRA leave for that person. It doesn't have to be related by blood, and they don't have to be family relationship of any kind. The designated person can be identified by the employee at the time that the employee requests the leave. So it doesn't have to be thought out in advance. But the employer does have a choice of limiting the employee to designating only one person for that 12-month period. So that's good to know. The next law, thank you, is AB 1751. So there's a presumption that COVID-19, if an employee gets it, the presumption is that they did get it at work through January 1st, 2024. So basically this presumption just got extended out. The California employer has the burden to prove that the employee did not contract COVID-19 at work. So if they cannot rebut the presumption, that means that the employee can then receive workers' comp benefits for their COVID illness. This law applies to all companies of 5 employees or more. The employee still does need to exhaust their sick leave before they're able to utilize workers' comp benefits. The presumption can be rebutted by evidence that shows that the employee did likely contract COVID somewhere outside the workplace. So if you have evidence somehow that the employee was at a super spreader event or something of that nature, then you have evidence to rebut it. Otherwise, it goes to workers' comp. The next law is AB 1949. So this is regarding bereavement leave. So up until now, bereavement leave is giving employees a few days, however many the employer they have discretion to decide how many before, if somebody of a close family nature passes away. But it's defined as a spouse, a child, a parent. It's a close family member. And before it was they could, you can give 2 to 3 days, however that was typical, and it doesn't have to be paid. Now it's a mandate that you have to provide your employees 5 days of bereavement leave. You don't have to pay for this leave. You can mandate it that they have to apply PTO or vacation leave if the employee chooses that. The one thing that kind of limits this is that they only have 3 months of the time that the family member passed away to use this leave. So you want to, I mean, all of these things we want to update your handbooks about, but this is a really important one as well. Thank you. The next one is AB 2693. What this rule, which takes effect January 1st, 2023, it changes the notification requirements of COVID-19. So now, unlike before, there's no longer a notice requirement to the local public health agency in the event of an outbreak. The California Department of Public Health no longer requires to make workplace industry information regarding COVID outbreaks and cases received from local public health departments available on its website. The definition of close contact has now changed. It changed actually a little while ago to mean we all have to be on mute. The definition of close contact has changed to now mean sharing the same indoor or outdoor space for 15 minutes over a 24-hour period with a person during the person's infectious period, whether or not they're symptomatic or asymptomatic. If there's exposure at the workplace, employers have to provide a written notification or a work site posting. If you decide to post, the employer, PTO is paid time off. Thank you. If they decide to post, the employer must, within 1 business day of getting notice of the exposure, prominently display a notice in all places where notices to employees concerning workplace rules or regulations are customarily posted. So on this notice, you have to say the dates on which the employee was on the worksite premises, the location of the exposures, including the department, floor, building, or other area. You just obviously don't want to specify who that person is. There's still confidentiality in that regard. You want to put the contact information for employees to receive information regarding COVID-related benefits to which the employee may be entitled. If it's workers' comp, COVID-related leave, sick leave, SPSL, supplemental paid sick leave, etc. You want to give the contact information for employees to receive the cleaning and disinfection plan that the employer is implementing per the CDC guidelines and under Cal OSHA ETS COVID-19 prevention program. The notice must be posted for at least 15 calendar days. It has to be in English, as well as a language understood by the majority of the employees. An alternative to posting a notice is to communicate the information in the manner in which the employer normally uses to communicate employment-related information, personal service, email, text messages, as long as it's reasonable to assume that the employee will receive that notice. So just so you know, if you are a practice or a medical provider that actually conducts COVID-19 testing or screening or provides direct patient care or treatment to individuals who tested positive for COVID, this law specifically excludes those doctors, those practices. So, so that's also important for you to know. The next law is SB 951. So this is the law that was designed to help lower wage workers gain access to family and disability leave benefits, PFL and SDI, by increasing the family and disability leave to help lower wage workers pay into these benefits who are paying into these benefits to access them when needed. So basically it just changes the formula to calculate the disability payments for disabilities that start after January 1st, 2025. It increases it from 60 to 90% of the share of workers' wages paid by SDI starting again on 1/1/25. So it used to be 40% of wages, which the reason why they changed it is because the government felt that it was deterring employees from taking these benefits. So if we increase the percentage, then they're more likely to take benefits if in fact they need them. Okay.
Next slide.
Yes, please.
Okay.
Okay, SB 1162. I think this is the one I'm getting most questions about. Under existing law, private employers with 100 or more employees are mandated to submit an annual employer information report to the federal EEOC. Employers are also required to submit a paid data report to the California Civil Rights Department. This used to be the California DFEH, and now it's called the California Civil Rights Department, on or before March 31st of every year. Existing law allows employers to satisfy the requirement by submitting this other form called the Federal EEO-1, which contains the same or substantially similar pay data information to this California Civil Rights Department. So now the new law, employers must submit a pay date report to the department by the second Wednesday of May every year, beginning May 10th, 2023. Employers are no longer able to satisfy the requirement by submitting the old federal form. It also expands the data which has to be reported by employers. It must now include the number of employees by race, ethnicity, and sex in specified job categories, meaning that the report must also include the median and mean hourly rate for each combination of race, ethnicity, and sex within each job category. So even contractors are covered under this law. There has to be a separate pay data report submitted covering those workers as well.
Renee, don't miss the bottom part.
Oh, sorry, hold on. We're covering it. The employer, if you have 15, so right, so all of that was for 100 or more employees. Employers with 15 or more employees, which is more likely everyone here, they have to include in all job postings the salary or hourly wage range that the employer reasonably expects to pay for the position. Thank you, Alexis. Forgot the part that actually applies to everybody. So it's quite onerous, and it's just a different mandate. So if you have questions about that, you can always reach out. Okay, so 1632, AB 1632.
Oh, that's me, I think.
Oh,
right.
Okay. No, I don't think so, but go ahead. Feel free to talk about it.
This law is another bananas law. This says that if you're open to the general public, if someone needs to use your restroom and they have medical documentation of having an issue such that they need to use the bathroom, you have to allow them to use the bathroom. So I can't imagine anybody's going to say, please show me your documentation that you need to use the bathroom. But this is now a new law in our state. It's not enforced by a private right of action. So someone can't sue you for denial of using the restroom, but the Department of Public Health can enforce this. This has to do, AB 2068 has to do with Cal OSHA health postings. It requires that employers post notices of violations in multiple languages, and this is enforced by Cal OSHA. Some of your practices are going to be exempt from certain Cal OSHA requirements if they're part of the aerosol transmissible diseases standard. You should know who you are. If you're part of the ATD standards, you have a separate set of rules and trainings and requirements annually. For most of our practitioners, they don't meet these standards and still have to comply with OSHA. And there's one more thing I wanted to mention about Cal OSHA. you do not have 26 or more employees such that you're subject to paid sick leave for COVID, you may still have a requirement through the end of this year for exclusionary pay. If your employees contract COVID because of a COVID positive person at work and they are sent home to isolate under the Cal OSHA emergency standards, you still have to pay them for their time off. So if you're a smaller practice, this rule also applies to you. Sorry that I didn't mention that before. Okay, Renee, that's you.
Okay, so this law bars employers in emergency situations from retaliating against employees who refuse to come to work because they believe that the workplace is unsafe. There's numerous exceptions for specified industries. You also, as an employer, cannot prevent employees from using cell phones to seek emergency help, assess safety, or communicate regarding the safety. And the employee must tell the employer about the emergency condition. They can't just say that there's something crazy going on and not actually tell you what it is and then have an excused absence. Okay, whoops, sorry. This one is regarding meal and rest breaks for public healthcare workers. It grants the same right to meal and rest breaks as to the private sector. Applies to private sector employees who provide direct patient care or support direct patient care in general acute care hospital, clinic, or public health settings. Entitlement is similar to the meal and rest break rights possessed by private sector workers. So there is an exception. If your workers are covered by a CBA, a collective bargaining agreement, meaning that they're union type workers, then the CBA is kind of the Bible for those employees. So you want to make sure, I mean, the wage and hour rules still are going to apply, but you have to always double check it with the CBA. That's really, really important. Okay. I'm struggling so much with this new law. I have issues with this. So there's a really long list that seems to be growing every single year of protected categories under FEHA, which is the Fair Employment Housing Act. So if you look at what those protected classes are, which are typically like sexuality and race and gender, nationality, religion, things like that, you cannot take as an employer adverse employment actions against employees if they fit into those protected reasons. So if you say I terminated them because they're a terrible employee and they come back and they say actually terminated me because of my religion, well, now you have a lawsuit where you have to show no, it's because of their it's because I have all this documentation to show why they're a terrible employee. So now there's a new category under FEHA, which is reproductive health decision making. So if an employee, comes to you and they say that they want to take time off now to get a vasectomy or undergo IVF treatment, or they're contemplating different birth control methods or whatever it is that has to do with reproductive health, and something that they're going through, trying to figure it out, then that's protected. And if you say, you know what, you don't have time to do this and we need an employee that's going to be here every day, well, now they can actually come after you for that reason. So it's just crazy because it's making it so difficult for employers to have to follow all these rules, and everybody seems to be protected. And now we have another whole new category. So that's also something that needs to be added and updated to your handbook. So that concludes all the crazy new employment laws for California for 2023. Hopefully you feel prepared to start the new year and be able to figure out how to implement all of these new laws. It's a really, really good time to order a new handbook. If you already have a handbook with us, we have a lot of LACMA clients, then we need to update them in order to be in compliance. Yes, we will provide this presentation to everybody here. Please let us know. I mean, we're here, we're a partner of LACMA. We've been a partner of LACMA for, I don't know, it's probably going on almost 6 years at this point. And we have such a specialized practice with employment law. We have a lot of medical practices. We know, not to be punny, but all the pain points for medical practices.
Good one, Renee.
Thank you. Having employees. And so we are here to help you in any way that you need.
I see a question in the chat. They asked if an employee has to take care of a parent in another country who's terminally ill, can they collect FMLA from the state?
So FMLA is job protected leave. It's not wage assistance. FMLA applies if you have 50 or more employees. The law that Renee mentioned is the California Family Rights Act. That applies if you have 5 or more employees. So yes, an employee, if they have to take care of a family member who's terminally ill in another country, they may be entitled to job protected leave. And then in terms of wage assistance, that would be the paid family leave program through the state that gives them a certain amount of their wages for 8 weeks during that leave.
All right, and then also another question is, if an employee tests positive for flu, could they claim workers' compensation if your office treats a lot of flu positive patients?
I don't think workers' comp apply. The rule, the presumption for the workers' comp is specific to COVID. I haven't heard of any presumption for flu cases. Have you heard that, Alexis?
No, I haven't.
Yeah, I think it's only specific to COVID.
Okay. Are there, we'll also send out the presentation and the video as well as the slides after the call today, so you all have access to the information. Are there any other questions they can answer you at this time?
Maria is raising her hand.
Let me, hold on, Dr. Limberis, let me unmute you.
Oh, hi. First of all, congratulations. This is almost incredible. I mean, it's a shock. Okay, so we are into major protection of workers. Okay, I buy that 100%. The problem now is, though, would anybody want to be in private practice?
That's
Why?
a very fair question. I mean,
why should they?
but that's why LACMA is here. It's to help protect the private practice, that you're not afraid and run for the door. It's not just private practices, it's all employers in California that there's so much burden on employers here to just do everything to protect employees. But it's a very fair question. We get that question all the time. And my statement is always, thank goodness for sunshine, because otherwise nobody ever in their right mind would start a business in California. But
well, I don't think so. I think we are the best, and I will continue to believe that. I don't think it's just as terrible as it seems, because the young people prefer to be employed. So that is good news for them. Let's put it like that. But the problem I have is this. If you do, like I am now, telemedicine, and you don't have, and you are in solo practice and you do consultations and forensic psychiatry, I guess none of these things apply to you.
Well, a lot of the employment laws still apply even if the employee is working remotely. And COVID has brought up a whole new slew of claims and causes of action, because your employees are subject to their meal and rest periods just as if they were in an office. They are subject to receiving compensation if they're having to use their cell phones or their Wi-Fi to do your business purpose. If you're not paying the reasonable amount of those bills, that could be a separate cause of action. So there's a lot of other things to comply with, and make sure that your workers' comp is covering your employees that are working remotely as well.
Okay, I see what you mean. Well, all right, buyer beware is the point here. And this is phenomenal. I must have been very naive, but okay, all right, the times are changing, and thank you for that. And that's all. I mean, it's a shock to the system, but I have signed up for change, so no complaints.
We're here to help. Please let us know if we can help.
Thank you.
There was also another question that was submitted before by the registrants. If employees are traveling from one office to another, can they get reimbursed for that mileage and time?
So the rule with that is that the first commute is on the employee. I mean, there's no reimbursement for just commuting back and forth to an office. If your practice is set up where you have employees traveling from different practices or different patients, or however it's set up, there's so many different models, then all of those in between travel times, you have to reimburse at the IRS mileage rate, which I don't even remember what it is now. It's like 56.
68.5.
Or
Yeah.
60 went up. Yeah.
I think it went down this year for the first time ever. Going up.
Up and down.
But yeah, it's really, really important because that's a wage and hour violation if you don't reimburse properly for mileage, and it comes with a lot of penalties if you don't do it properly. So so the answer is yes, but that first commute, unless if they always are working at one hospital and then or one doctor's office, then all of a sudden you say, oh, today you're going to actually start your job, in Lancaster, and it's like 100-mile difference, that commute is going to be reimbursed. But typically your day-to-day commute is not reimbursable.
And another question, if you use your cell phone for work, what is the amount that should be reimbursed?
It's a great question, and I wish we had a black or white rule for this. And unfortunately, the legislature left that as a reasonableness standard. So you really need to think about how often your employees are using their cell phones for a business purpose and what their monthly bill looks like, and then pay a portion of that bill. So you kind of want to conduct a bit of a study to figure out how much time, how many hours, and are they using a lot of Wi-Fi data to come up with their number. But you want to make sure that you are reimbursing it and it's not taxable to the employee, which they like. So just put that as a separate line item on their pay stub that you're reimbursing for cell phone use.
Okay. And then someone asked about employee handbook creation. So I'll definitely send out your contact information so they can get in touch with you on how to put a handbook together for their practice.
And just for clients that we haven't worked with before, we do have packages that we offer. We have 3 packages, and each package has just different levels of service. Every package has an employee handbook, and then it goes from that to HR audits, which are really, really critical and comprehensive. And then each package also has built-in amount of hourly advice. And then sexual harassment training. We didn't talk about that today, but that's still a requirement under California law every other year for any company of 5 employees or more. So we offer that as well. And that's part of our 3rd package. So we can, if Lisa, if you want to send out, because we also have special pricing for LACMA members, all of the services we provide LACMA members have special pricing. So we can send those to you as well.
Perfect. And then another question came through. If you pay out unused sick time as a thank you gift, does it need to be disclosed?
To who?
So there's no requirement to pay out sick time when someone leaves your practice. You do have to pay out vacation time because that's considered earned wages. Or if you have just one general PTO plan that covers both sick and vacation, you would have to pay out whatever's in the PTO plan. If you pay out sick as a gift, I would want you to get something in return, like a severance agreement that the employee is not coming after your practice and in consideration for being given this extra money. But if that's not going to apply, just document it. As a thank you for your past service, we decided to pay you out the sick time, which we don't have to by law.
Great. All right. If there aren't any other questions, thank you, Alexis and Renee, for your very informative presentation. We'll be sending this out to all the registrants after the presentation. And if there's any other questions too, you can feel free to reach back out to us, and I'll also include Alexis's and Renee's contact information to reach out to them directly. So thank you all for your time today, and have a great rest of your day.
Thank you.
Happy holidays, everyone.
Happy holidays.